The conclusions I'm going to reach today were prompted in part by a recent conversation with another linguist, one who has a great deal of experience in court cases, who said to me that he would never again testify with respect to either speaker identification or authorship attribution because we don't know enough to reach conclusions that are scientifically valid. That conversation reminded me that while I have worked on a number of these cases over the past 20 years, I have actually never testified in one of those cases. I have prepared expert reports based on analyses in authorship attribution and in speaker identification cases, but in no case have I ever actually testified in court. In one of the early cases I worked on, I was actually appointed as a court-appointed expert, and the judge agreed in advance to be bound by my conclusions. In all the other cases, my report was used as what I'm going to call a kind of elaborate discovery procedure, and in no case did I testify or in fact need to testify, because in every case, in the civil cases, there was a settlement, and in criminal cases, there was eventually a guilty plea. If you listen to CNN this week with respect to analysis of the recent tape claimed to contain the voice of Osama bin Laden, you perhaps heard Paul Ginsberg make conclusory statements like this. Asked whether it's Osama bin Laden's voice, he said, on the basis of our analysis, I would not rule it out. He also said it may or may not be. Those statements may be okay for agencies and commissions, but they're not okay from a linguist on the witness stand, certainly not in federal court, as most of you know. The main topics I'll talk about today are a brief description of some uses of linguistic analysis in a series of court cases, and I want to introduce this by suggesting to you that the problems, as most of you know, are that there are too many variables of unknown significance, as well as what we might call a frequency of occurrence problem, so that we can establish group norms and say both these kinds of cases, but not individual norms. I think because these issues are extremely important in both civil and criminal cases, linguists have a clear responsibility to address the issues as well as possible. One of the problems is our need to, in federal court at least, address the issue of the new Federal Evidence Rule 702 standard initiated by the Daubert-Kumo cases that some of you are familiar with. The rule reads as follows. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise if the testimony is based upon sufficient facts or data, if the testimony is the product of reliable principles and methods, and if the witness has applied the principles and methods reliably to the facts in the case. The issue for us often is the sufficient facts or data. There's an overview of contemporary research in McMenamin's 2002 book, Forensic Linguistics, Advances in Forensic Stylistics. He talks in there about Ted Kaczynski's manifesto, about the John Benet Ramsey ransom note, about the anthrax letters, if you want to read something about this. Of those researchers looking at these kinds of cases today, two I want to discuss in a little bit of detail are Don Foster and Carol Chasky. You may know Don Foster, who's an English professor at Vassar. As a researcher, he bases his claim of expertise on authorship on a kind of stylistic analysis like that he has used in identifying authorship in literary works such as Shakespeare. Unfortunately, relatively recently, his varying conclusions in the John Benet Ramsey ransom note case suggest that his techniques don't stand up to scientifically validated techniques. You may recall that he initially identified the author of the note as someone other than John Benet's mother, and later, in fact, announced that John Benet's mother had written the note. There's a lot on the web about that if you want to look at some details. Carol Chasky is an independent scholar. She runs the Institute for Linguistic Evidence, and in a long article published in Forensic Linguistics 2 years ago, she has summarized some research that she's done in which she claims that syntactic analysis and syntactically classified punctuation are the only two areas that really yield reliable results. She also looked at sentential complexity, vocabulary richness, readability, content analysis, spelling errors, punctuation errors, word form errors, and grammatical errors, and suggested that these fail to usefully differentiate authors. I have used a series of these kinds of features in a variety of cases, which I'll now discuss very briefly. In one civil case, for instance, now this was in probate court, there was a will contest. The issue was who had actually composed late changes to a will, not who had written it, the handwriting was not an issue, but who had actually composed these items. In this particular case, it was a very unusual fact available. The players were Mama, who had died at an advanced age, daughter, son-in-law, and son. A few months before Mama died, she changed the contents of her will drastically, leaving everything to daughter and son-in-law and nothing to son, in contrast to earlier proposed dispositions. About the time that this happened, the stylistic nature of Mama's letters changed radically. Now, in this particular case, what was most interesting was the amount of data available to me. For some reason that I'm sure she deeply regretted later, daughter had always kept every letter written by every member of the family. I had literally hundreds of letters from every player, from Mama, from daughter, from son-in-law, and from son. I had a huge body of data. It was quite clear that the letters and will and other documents written by Mama late in life matched the stylistic attributes, particularly of son-in-law, who was a lawyer. There was actually no question but that she had been influenced either by someone dictating or handing her a script to follow when she wrote out documents in her own handwriting. It was a massive case. It went on for a long time. Actually began a telephone deposition at one point, and it was broken off for various reasons, and that case eventually settled. A little unusual to have that kind of civil case. Now, we'll discuss also a series of criminal cases in which authorship, attribution, or speaker identification are at issue. Briefly, one on speaker identification. A defendant was accused of felonious selling of cocaine to an undercover agent on the basis surreptitiously made audio recordings of unambiguous transactions. The defendant said, "That's not me on the tape." The surreptitiously made tape was an extremely poor quality. I'm also not a phonetician. I don't do spectrographic analysis. I pass that on to someone else if it seems to be needed. In this particular case, however, what I actually did at the request of the attorney was prepare a new transcript of the audio tape, prepare a script, get a voice exemplar recording of the defendant himself. There were such gross differences in pronunciation features and morphological features between the two samples that we had, small as they were, that I concluded that the linguistic evidence suggested strongly that, in fact, this was not the same speaker. Now, I want to introduce a brief anecdote at this point and tell you that I had a very early education in some of these issues. As many of you know, in the early 1980s, because of my new interest in the role of language in legal process, particularly comprehensibility of jury instructions, I actually went to law school while teaching at the University of Tennessee. And as a first-year law student, I had a very, very important lesson in some of the issues involved here. You probably know that the first-year law students take all their classes together in sections. So I was in a section of 80 people, and we had all our classes together for 1 year. In the spring, we took a criminal law course that was required. It's kind of a strange course. We had a new professor. Didn't really kind of seem to be up to snuff. He would, instead of lecturing, he would often read from various guides that we had access to in the bookstore. And it was kind of a strange course. He let us talk a lot, and I like to talk, so I talked a lot. This professor followed the usual format that our grade would be based on a single, anonymously graded final examination. Total grade 4.0 down to 0.0, the usual arrangement. However, he said that he would give a practice midterm for those who wanted to take it, and he would grade those so that we have some indication of how he would grade. Well, I was going to have to be at a conference the week he gave that test, so I could not take it. About a week before the class was over, he called 3 of us into his office and announced that because of our contribution to discussion, we were going to be awarded partial points prior to the examination. So I went into the exam having already been awarded 0.2. So I knew I wanted to make a 0.0 in that particular class. Took the exam and then went to see the grades when they were posted. And I had the high grade in the class. I had a 3.9. What I learned over the next several weeks, eventually from the professor himself, I'm sorry to say, is the following. One of my friends, whom I call Andy, noticed during the semester that, number 1, I like to talk a lot, number 2, the professor let me talk a lot, and number 3, the professor seemed to like me. So Andy decided that he would keep notes on distinctive words and phrases that I use, and he would, on the final examination, make every effort to sound like me.